Good morning, everyone. I am Sara Corradi, and I will be one of the judge of your preliminary of your moot court. If I'm not wrong, my co-judge is still not into the meeting, so if you don't mind, we can give her the possibility to join the meeting, and maybe also more students will join, because I can see that I'm not sure if all the students are in.
Thank you, Sarah. This is Delvin here. We are trying to reach Manar, but if in a few minutes she doesn't join, please proceed and start until we have been able to reach her.
Perfect. Thank you, Delvin. I can see that it should be also Mr. Mohammed Emara as a standby judge. I'm not sure. I don't see him, so I'm not.
Yeah.
I'm not
No,
sure.
yeah. So we're trying to reach.
Okay.
Yeah.
Thank
No,
you
we're
very
trying
much.
to reach
Thank
both.
you.
Hopefully, one of them will be able to join. Thank you,
Thank
Sarah.
you.
Thank you.
Good morning and good afternoon again. I think we could start because it's already 1:10. So I will kindly ask, so we have, let's check if we are in the correct courtroom, and there will be Middlesex University K as appellant and Lebanese University team as respondent. Please let me know if it's correct. I think yes, I will be the only judge. There is someone from Middlesex University, Team K.
Hello, good afternoon.
Hello, good afternoon.
Do I begin?
Yes, just a brief introduction from my side. Yes, as you know, there will be the hearing will last 90 minutes, and there will be 45 minutes each team. There will be a senior appellant, a senior respondent. Then there will be a few minutes for the rebuttal of a senior appellant. Then, if you want, I can leave you 5 minutes to discuss within your team, and then there will be the junior appellant, the junior respondent, and then a brief moment for the junior appellant rebuttal. Before starting, I would like that the team will make a presentation of itself, a brief presentation with the members of the team, and please let me know who will be your oralists. It will be the same for senior and junior, or if you change the oralist. Just a brief introduction in order to know you better. Thank you.
Good afternoon again. For Middlesex Team K, we are a team of 4. And for this round, it's going to be myself, Nada Yahya, and my co-counsel, Nisreen Hamadi, who will be the oralist for this round, representing the appellants.
So I'm writing properly your name. Okay. Nada, correct? Kind of.
Yes.
I apologize for my bad pronunciation. Okay, you can start. Just for all the oralists, try not to read, please. Of course, you will have your submission, your written submission. That will be the basis for your oral exposition now. Try not to read. Try to talk with me and explain the reasons of your client. Please, the stage is yours. Sorry, just another question. Do you already know how to manage your time? So you have 45 minutes. You will talk for 20, 30. How you will manage the timing and also the topic, the topic that you will touch, the arguments that you will touch. Do you internally decide how to manage?
We have internally decided how to manage. I will be discussing the first ground, and my co-counsel will be discussing the second ground, and we will take a maximum of around 10 to 15 minutes each.
Okay. Okay. Sorry. Please, the stage is yours.
Thank you. May it please the court, my name is Ms. Nada Yahya, and I appear for the appellant, Mr. Laith Payne, along with my learned junior, Mrs. Nisreen Hamadi. My learned friends in the opposite appear for the respondent, Mrs. Raz Rani. Would your ladyship find a brief summary of the fact of the case helpful?
Sure. It's very helpful, and also when you do this kind of exercise, this kind of competition, is very good. It's not just repeat the fact, but it's already the facts. You expose the fact to the judge in a way that are already connected with your defense, with the defense of your client for the future of your dissertation. Please.
Yes, Your Ladyship. So the fact of the case are as follows. The parties have created an algorithmic program to buy and sell a cryptocurrency called YAPL. The respondent created the program called Alpha, which buys the YAPL at the best possible price on the platform. On the other hand, the appellant has a program called Beta, which sells the cryptocurrency YAPL at the best possible market price on the platform. However, Beta is also coded to sell YAPL at a highly inflated price if there is no one selling YAPL on the platform. Therefore, on June 10th, 2022, the Clevity platform underwent a software upgrade, which excluded all trade marketers who had less than $200,000 in their account, which consequently made the parties the only permitted traders on the platform. So as a consequence, the programs conducted what they were originally programmed to do, which is the fact that Beta made the YAPL price highly inflated, which is at the time the best possible price in the Clevity platform, according to the market, and Alpha agreed to buy it. Therefore, the transaction was concluded and the appellant sold 100 YAPL to the respondent. If Your Ladyship does not have any further questions on the fact of the case, I shall proceed to my submissions.
Yes, please, go ahead. Thank you.
Your Ladyship, the appellant argues against the judgment of the Court of First Instance on two grounds. The first ground, which will be dealt by me, is as follows. The DIFC court judge erred in concluding that the DIFC has jurisdiction over the dispute under the Article 5A1B of the Jurisdictional Authority Law 2004 due to the fact that Clevity had a serve node based within the DIFC. The second ground will be dealt with my learned junior, Mrs. Nisreen Hamadi, which is as follows. The judge erred that for the purposes of Article 37(1)A of the DIFC law, the court did not need to examine the state of mind of the programmer when designing the program. If it pleases Your Ladyship, I shall begin with the first submission. The appellant submits that the DIFC courts do not have jurisdiction over the disputed trade due to the unrecognition and prohibited cryptocurrency or crypto token YAPL. The DIFC has a regulatory framework for virtual assets such as NFTs, and in our case, cryptocurrencies, under the jurisdiction of the Dubai Financial Service Authority, which I will from later on refer to as DEFSA. DEFSA is the financial regulatory authority within the DIFC. The DEFSA rule book states in A25.1 subsection A that a token is a crypto token if it is used or is intended to be used as a medium of exchange or for investment purposes. Therefore, YAPL is in fact a cryptocurrency because it is used by the parties to buy and sell YAPL to gain profit and invest on the crypto token YAPL in itself. I would like to bring to your attention, my ladyship, the Protocol of Jurisdiction 2004, Section 3.3, which states that the DIFC courts shall have exclusive jurisdiction over disputes arising from transactions related to financial activities licensed to be performed within the DIFC. Which brings us to the DEFSA rule book, Article 41A3B of the regulatory law. Financial product is also prescribed to mean a crypto token, which means that YAPL crypto token must be a recognized and licensed crypto token, perform financial activities within the DIFC in order for the DIFC to have jurisdiction over disputed transactions. The DEFSA rulebook, section 3A 1.1 subsection A, defines algorithmic token as a means of a crypto token which uses or intends to use an algorithm to increase or decrease the supply of crypto tokens in order to stabilize its price. This is demonstrated by the fact that beta is coded to sell YAPL based on the best market price. However, if there are no users selling YAPL on the platform, beta automatically offers YAPL at a highly inflated price to increase and preserve the value of YAPL, which will therefore increase the supply and demand for YAPL for investors and stabilize the price of YAPL. However, Rule 38.2.3 under the DEFSA rulebook prohibits activities in the DIFC related to algorithmic tokens. Consequently, YAPL is considered a prohibited crypto token under the DIFC because it involves the use of algorithms. The DEFSA guidelines under 3A.2.1 states that it is prohibited to engage in activities with unrecognized crypto tokens, such as having exposure, using directives, and tracking an index that includes unrecognized crypto tokens. Therefore, the Clevity node server based within the DIFC are prohibited from engaging and tracking transactions of YAPL because it is an unrecognized cryptocurrency as well as a prohibited cryptocurrency. Thus, the disputed trade did not happen in part or wholly within the DIFC and did not satisfy Article 5A(1)(b) of the Jurisdictional Authority Law 2004. In conclusion, Your Ladyship, the judge erred in concluding that DIFC courts has jurisdiction under Article 5A(1)(b) due to the fact that Clevity has a node server based within the DIFC, and the judge should have instead held that the DIFC has jurisdiction only over recognized and unprohibited cryptocurrencies or crypto tokens under the conditions stated in the DEFSA rulebook. Therefore, the dispute trade is outside the scope of the DIFC's jurisdiction. If I could be of further assistance to the court, this concludes the first ground for the appellant.
Thank you very much. Yes, I have a question for you. So, according with your submission, there is no jurisdiction of the IFC in this situation, and it was very, very clear, explained. So, I would like to do a step forward. Which jurisdiction do you think it could be instead apply to this kind of contract, or to this kind of dispute?
So as in terms of the DIFC, the DEFSA does not recognize the YAPL because it is using algorithms, and so for it is not a recognized cryptocurrency, as well as it's also prohibited for the DIFC to use to have any jurisdiction in prohibited cryptocurrencies. So the answer to your question, Your Lordship, Your Ladyship, is that the jurisdiction that could take on the issue would be a jurisdiction that does not see algorithmic tokens as a prohibited crypto token.
And thank you very much. And in your opinion, which jurisdiction and why it could be applied? For example, due to the element that you have within the test. So let's be always close to the fact that we have in the test.
Your Ladyship, I do not have an answer for that at the moment. However, if you would like me to go back to your question, you give me a moment to look into it.
Yes, thank you. I was especially thinking about the place of residence of the two physical persons that are involved in the case. For example, one is a resident in Dubai, not the IFC, so Dubai Mainland, and the other part is resident in Oman. So, for example, if something can be connected with this, if you want to think about, we can discuss later. Do you want to add something, or we can move forward?
We can move forward, but I would like to answer your question later on in the day.
Sure, sure. Thank you very much.
Thank you.
Okay. I will now move to Lebanese University team with the senior respondent for the Lebanese University team. Please, the stage
Good
is
evening,
yours.
Your Honor.
Hello.
Good evening, Your Honor.
Good
Hello,
evening.
how are you?
All good. Hope the same for you,
My name,
for all the team.
yes, my name is Safa Zahreddin. We are generally a team of two, me and my colleague Gina Matar. I am going to be the respondent, the senior and the junior, both of them, because we are a team of two only.
Sorry, the line is not very well. Do you mind to raise the volume, if it's possible, or
Yes,
your
yes, I will.
microphone? Thank you
Okay.
very much.
Okay. I was saying that we are a team of two only, so I will be the junior and the senior respondent.
Okay.
Okay. Do you want me to go through the facts or directly to the grounds of the field?
As your colleague previously, it will be very important to explain me the facts and already in connection with your defense for your
okay,
with defense of your client. Okay. The stage is
okay,
yours.
great. Okay.
Thank you.
Both the respondent and the appellant are both users of a platform which is called the Gravity platform, which is a platform that we can trade cryptocurrency on this platform. The respondent resides in Dubai, in the UAE, but not within the DIFC, while the appellant resides in the Sultanate of Oman. A Gravity platform, one of the characteristics of the Gravity platform that it's a distributed ledger. It's a decentralized ledger which is hosted across many nodes across the world. Gravity permits users to go to trading of cryptocurrency by specific programs. The respondent program is called Alpha. Alpha is programmed automatically to buy a cryptocurrency called Yapel at the best price available at the platform. While the appellant's program is called Batta. Batta is a program in a way to sell Yapel, Yapel, which is the cryptocurrency, at a price based on the average price for the Yapel. However, Batta is also programmed for such a way to offer to sell Yapel on the Gravity on the one if there are no users offering to sell Yapel other than Batta. Batta automatically offers Yapel to sell at a higher inflate prices. On 10 June 2022, due to a software update on the Gravity platform, an error took place where all the other traders were excluded by the software of the platform, and only the respondent and the appellant were at the platform to trade cryptocurrency. Thus, Batta automatically sell Yapel at a very high very high price to the Alpha program, which was programmed by the appellant. Thus, the respondent issued a proceeding before the IFC Court Digital Economy Court, seeking a declaration that the disputed code was void for unilateral mistake. I proceed to ground one, Your Honor.
Sorry. Yes, please. Go ahead. Thank you.
Okay. First, I'm going to, after I give a brief of the facts of the case, I'm going to address the grounds of appeal to convince Your Honor that the first instance court was correct in its decision by dismissing the appellant's application. First, I will start by ground one. The IFC courts have jurisdiction over the claim. First, I will share with you what Article 5A1 subsection B states. This article that defines or indicates the jurisdiction of the IFC court says that the court of first instance shall have exclusive jurisdiction to hear and determine civil or commercial claims and actions arising out of or relating to a contract or promised contract, whether partly or wholly concluded, finalized, or performed within the IFC, or will be performed or is supposed to be performed within the IFC pursuant to express or implied terms stipulated in the contract. Now I will explain briefly the characteristics of the distributed ledger and blockchain and nodes. Distributed ledger is a decentralized network that is geographically distributed across many nodes in different states and countries. The nodes, the characteristics of the node, that every node is considered a mirror copy of whole platform. That means every node has a copy of the whole platform, and every transaction that takes place must be hosted by every single node. Every single node verifies this transaction and broadcasts it into the other nodes. So, according to what I said regarding the characteristics of the distributed ledger and the nodes, that every node is considered broadcast and verifies every transaction that takes place. Due to this characteristics, courts nowadays are taking into consideration the location of the nodes to be relevant for the judicial analysis. Here I'm citing the following precedent, which is U.S. Securities and Exchange Commission versus Ian Balina 2022 Western District, Texas, number 950. And this said precedent, the court considered that this precedent is related to the Ethereum cryptocurrency. According to this precedent, the transaction of the Ethereum of that case was verified by nodes which was located in the US. For that reason, the court back then considered that because this transaction was verified by nodes that was located in the US, thus the jurisdiction of the US court is met. So, according to what I have mentioned above regarding the way nodes operate in the distributed ledger, thus we can conclude that the disputed trade is considered to be taking place within the DIFC in accordance to the Article 5 A1 subsection B. Another point of view that aid my previous point, that is there's a precedent that is citing Al-Khurafi versus Bank Saracen, DIFC number 3 and 5 January 2012. This precedent considered that any incident related or was a result of an activity that a commercial activity that was taking place within the DIFC, thus the jurisdiction of the DIFC is met. So, as a conclusion, because nodes are the characteristic of nodes and disputed ledger are considered that every transaction must be or is verified by every node, as if you want to give an example, as if every node is doing this transaction. So every transaction must be verified by every node. For that, we can consider that this disputed trade has taken place within the DIFC, and thus the DIFC courts have jurisdiction according to the Article 5, A1 subsection B. Your Honor.
Okay, thank you very much. So, yes, I would like to ask you if you have some observation to do to the other team, to the other councils regarding the jurisdiction, of course, the jurisdiction of the IFC, and especially regarding the nature of this cryptocurrency, because your colleague made a pretty long exposition concern the nature of this kind of algorithm, the nature of this kind of cryptocurrency, and she arrived at the conclusion that it was not possible to apply the DFC regulation due to the fact that this specific operation is one of the out of scope. We have to define them as out of scope operation. So do you have any observation regarding this?
Yes, I may have an idea. I don't know. Let's say if we want, let's say that we take into consideration what my colleague have said earlier. But here we are talking about jurisdiction. We are not talking about the nature. For instance, let's say that what she said was right, and this cryptocurrency is not considered a crypto, or this DIAPL is not considered a cryptocurrency. But here we are talking about jurisdiction. We are talking about jurisdiction of a specific court. So here we apply, but in the merits of the case or in the subject of the case, we might talk about the nature, if it's prohibited or not prohibited, if it's considered a YAPL, a cryptocurrency or not. But here we are talking about jurisdiction for a court in a way that we apply for example, Article 5A1B, according to this transaction, whether this transaction is prohibited or not prohibited. Your Honor.
Okay, thank you very much for your answer. I would come back to counsel for Middlesex University, for Mr. Payne, if she's ready to answer regarding the possibility of mention another jurisdiction. So if it is not DIFC jurisdiction, which kind of jurisdiction we can invoke if you are ready? Otherwise, we can go ahead and so because I just wanted to close the jurisdiction ground. This is why I'm doing the question now. But if you are not ready, we can keep it open and proceed later. Thank you.
Your Ladyship, I have the answer for your question. The Central Bank of Oman has created a note in behalf of the Royal Oman Police. They state that the cryptocurrencies are not a legal tender in the Sultanate of Oman. Therefore, cryptocurrencies are not regulated in Oman either. So my learned friend on the opposite for the respondent stated that I have been discussing about the nature of the crypto token. The crypto token YAPL is a crypto token. However, it is a prohibited crypto token, meaning that DIFC cannot regulate and cannot have jurisdiction over a crypto token or a cryptocurrency that is prohibited or unrecognized by the DEFSA, which is the regulatory authority within the DIFC.
Thank you. Thank you. Interesting.
Thank you.
And if we want to move forward from the concept of illicit activity, and we want to adhere just a broad concept of jurisdiction, which jurisdiction you would apply? Let's make the hypothesis that the transaction is legal. It's totally legal. It's a common transaction. Which jurisdiction you would apply?
So, Your Ladyship, just to reiterate your question, you're asking if the transaction happened in the DIFC court and the crypto token is considered as legal and recognized and unprohibited, which jurisdiction would I apply?
Exactly, due to the fact that according with your position as counsel, you deny the jurisdiction of the DIFC.
Okay.
Thank you.
So despite,
I hope it's clear. Please let me know. I try to explain better. Thank you.
Thank you, Your Ladyship. So despite the fact that I have acknowledged the fact that the cryptocurrency is unrecognized under the DFC and it is a prohibited crypto token, which is not allowed, which means that the DFC are not allowed to engage with them. If we put that aside, then yes, the DIFC court does have jurisdiction to go forward with the transaction as part of the Digital Economy Court of Part 58, which has the jurisdiction to look over disputes of virtual assets such as cryptocurrency.
Perfect.
Thank you.
Thank you very much. So now, if you finish your submission, your oral submission, you don't have anything else to add. I'm also talking about Lebanese team, SAFA. I will proceed with the rebuttal for the senior appellant, senior counsel appellant. Nada again, correct?
Yes.
Okay. If you have any observation to do regarding the grounds of Mr. Safa, thank you.
I think I already mentioned, I think I kept the rebuttal with the answer to your question, Your Ladyship. So I hope you could take that into consideration.
Perfect. Thank you very much.
Thank you so much. Thank you.
Thank you. So far, if you want, I can give the team 5 more minutes to organize the second part, the second grounds, or if you are ready, we can start with the junior appellant. Just let me know if you want. It's totally fine for me. We are in time, so we have time. Thank you.
I'm actually ready, Your Ladyship, so we can start if that's all right with you.
Perfect. So for Middlesex University Team K, we have Nashreen, correct? Hamida
Yes,
Bhatt.
Nasreen. Yes.
Okay, just let me 1 second to write properly your name. I apologize for my bad pronunciation of your name. I'm sure it's not correct. Sorry. Okay.
Your Ladyship, can you see me?
I can see you. I can hear you. Not the best, but I can hear you. I don't know if you can do something with your volume of the microphone.
Okay. I will do my best to speak louder.
Thank you very much. Very much appreciated. Okay. The stage is yours, please.
Thank you, Your Ladyship. May it please Your Ladyship, my name is Nasreen Hamid and I appear as junior counsel representing the appellant Mr. Leith Payne alongside my learned co-counsel Ms. Nada Yahya, who appeared as senior counsel for the appellant. Your Ladyship, I will be dealing with the second ground, which deals with the question under the DIFC contract law. Would a reasonable trader with knowledge of the circumstances surrounding the transaction conclude that the disputed trade was the result of an error? So, Your Ladyship, I will be exploring and examining the facts of the case under the perspective of whether or not the transaction was erroneous or was the result of an error or a mistake. In relation with the second ground, Your Ladyship, I have 3 submissions to make. So if it pleases Your Ladyship, I will now begin with my first submission. Your Ladyship, Mr. Payne did not commit what can be categorized as a mistake. He programmed his program in such a manner that if there were no other users offering to sell Yapple on the Clevity platform, the crypto token would be offered for sale at a higher or a more inflated price. This can be seen as what is a rather known commercial tactic that is used often in the commercial world. So at the time of the glitch, there were no other users offering to sell Yapple on the Clevity platform other than Mr. Payne. So that's the way that the program was designed. Thus, the program had acted in the way that Mr. Payne had intended, which is to increase the value of the crypto token Yapple in the times of the token being rare, scarce, or not easy to obtain. So there is no mistake in that sense in the way that the program had carried out the transaction. Further, Your Ladyship, as established in the DIFC contract law, law number 6, to be specific, of 2004, under Article 37(2)(b), it is stated that a party may not avoid the contract if the mistake relates to a matter in regard to which the risk of mistake was assumed. So, which brings me, Your Ladyship, to my second ground, which will address with what I had just mentioned regarding the element of risk in the instant case. As Ms. Razi had created the Alpha program herself, she should be aware that it is inherently risky for her to code the software to complete transactions automatically on her behalf without the need of human approval or consent per se before each trade. Therefore, it is plausible to assume that the electronic program at the time the transaction was made was completely legal. Looking at it from that perspective, the glitch that occurred did not make the transaction invalid, as both the programs ran as coded by the parties. I would like to refer Your Ladyship to the case of Smith and Zimbalist, where it was established in the California Court of Appeal that it was established that that parties dealing with inherently risky business practice, such as the buying and selling of antique guitars, should assume the uncertainty that comes with such practice. In the same sense, Your Ladyship, Ms. Razi should have assumed the risk that comes with behind coding a program that automatically completes transactions legally on her behalf. In the instant case, Your Ladyship, Mr. Razi should have expected that from time to time glitches do happen in platforms such as the Clevity platform, and therefore she must have assumed the risk and taken responsibility for the glitch that took place, and therefore taking also the responsibility for the transaction being carried out in the way that she had coded exactly. Lastly, my ladyship, I will now be moving to my third submission. I would like to refer Your Ladyship to the International Institute for the Unification of Private Law of 2004. So specifically under Article 3.4, the definition of a mistake is, and I quote, an erroneous assumption relating to facts or to law existing when the contract was concluded. My ladyship, at the time the trade took place, Mr. Payne's Yapple token was factually the best possible price available on the Clevity platform. So, Your Ladyship, under this definition provided in this legal source, the definition of a mistake does not fit what had happened on Mr. Payne's behalf. As established previously, Your Ladyship, the program had run as coded by Mr. Payne and by Ms. Razi, exactly the way in which they had both predetermined, planned, and coded. Further, Your Ladyship, I would like to refer you to Article 37(1) of the DIFC Contract Law number 6 of 2004. It is provided that a party may only avoid a contract for mistake if the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it at all if the true state of affairs had been known at the time of the conclusion of the contract. So in the instant case that we are dealing with currently, there existed no possibility for Mr. Payne to predict the glitch in the program or by any means anticipate that the glitch would have happened in the Clevity platform and maybe controlled the situation. The glitch was caused by a completely independent reason that did not have any connection per se to Mr. Payne. All that had occurred was the lawfully executed transaction, as both beta and alpha had been coded by the parties. Your ladyship, it is for the reasons that I have just provided and for those that have been given by my co-counsel that I urge you to allow the appeal. And unless I can be of further assistance, that concludes the submissions for the appellant. Thank you very much.
Thank you. Thank you very much. So I will go straight to Lebanese team again. So Mr. Safa.
Yes,
Please,
Your Honor.
Please, the stage is yours for your ground to submission. Thank you.
Yes. First, I want the judge here was correct in concluding that for the purpose for a claim to avoid the disputed rate, it was sufficient here to satisfy the Article 37(1)(a) from the IFC Court's Law Number 6 of 2004. Only that a reasonable trader with the knowledge of the circumstance around the transaction would not have concluded this disputed rate unless he was in an error. Here, first, before it's clear here that the mistake in the present case qualifies as a mistake under Article 37 of the DIFC Court Contract Law, because this mistake was of such importance that nor the respondent nor any reasonable person in the same situation would have accepted this trade. And that is and what assumes and what assures this idea that the respondent had programmed Alpha to buy Yapple at the best possible price available. But however, this programming is to buy Yapple at best price is one. These prices must be normal, not through and because of an error that caused inflation and caused disruption in the price of the Yapple price. Here, I want to cite Hallison versus Hazel, the IFC President 2017, number 86, 18 May 2017. And this precedent, the court considered that the mistake or this mistake if a party, if a normal party or normal trader wouldn't accept or enter this transaction, this is considered a mistake that qualifies under the Article 37 of the DIFC Court. In addition, this disputed rate took place due to an error. For that, if this error hadn't taken place, this trade wouldn't have been concluded. For that, it's enough in this case because also of the principle of equity. We can't assume that this contract is correct while it was concluded because an error that took place. And when the respondent programmed her program, her consent was to sell Yapple at a not inflated price, at a best normal price, not a price that was derived from an error that caused abnormality and disruption in the prices of the Yapple, of the price of the cryptocurrency. Also, I want finally to refer to the Article 37(1) subsection A that states that a party may only avoid a contract for mistake if when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it if the true state of affairs had been known. First, this condition is met. As I mentioned before, this disputed trade was an error, and the respondent nor any trader and exactly a reasonable person or reasonable person, a trader, would have entered into this transaction. Second, I want to refer to the last paragraph of this article that states and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. This transaction is not reasonable first, as we said, and is not fair and equity to leave the respondent in such an error, because this transaction is first we have unfair and was through an error that caused this inflammation in the prices. Your Honor.
Thank you very much. Sorry, I just would like to ask you if you can repeat the citation regarding the IFC case Halston versus Hazel, because unfortunately the line is a bit disturbed and I didn't understand all, so I kindly ask you to repeat. If you can
of course.
speak a little bit slower, thank you, because I have something in the back that do a strange sound. Thank you very much. I will also inform the technical team if can help for the next round. Thank you very much.
Only 1 minute. Only 1 minute.
Sure. Take your time. Take your time. We have time. Don't worry.
Oh, okay. This is and actually I cited my skeleton argument to precedent. They are the same meaning. So I will talk about what I talking about, which is Hazel, Halston and Hazel, right? You were asking me about the citation of Halston.
Correct. If you can repeat kindly why you cited this judgment and the connection of this judgment, of course, with the facts that we are discussing. Thank you.
This precedent stated that it's clear from from the other case that from the defendant's submission that it would not have entered into the compromise agreement in its final form had it been aware of the true state of affairs. Here I cited this precedent to prove that the mistake under Article 37 must be a very a mistake. No one or the conditions of the mistaken or the disputed trade, there no reasonable trader or reasonable person would enter into this transaction if he had known the true state of the affairs. If he knew what was the conditions of this or the conditions of the transaction.
Thank you very much. And then I can read in your written submission, you cited also, I would say, one of the leading cases in this area in common law of electronic contract, this kind of contract. You cited the Singaporean court case, Kinoe versus B2C2. Could you please explain better what you understood with this case, how you can apply the principle of law that the judge decided to apply to this case to our case, please? Thank you.
In this case, they considered that there was a major database breakdown or error with equivalent effect. They considered that, as I took from this, I understood the precedent that this error, or that as they said, that they defined as major database breakdown, this led to the transaction. For that, here the mistake was a very obvious mistake, and this error or this major database breakdown, which led to the transaction and to this contract. I understood this from this precedent.
And what the judge underlined in this case, especially from the point of view of the unilateral mistake, the doctrine of the unilateral mistake, because the fundamental of ground 2 of your submissions is the doctrine of unilateral mistake. So what do you understand? What you can take from this case and actually apply to our case? What do you think are the grounds in common that you can use? Thank you.
Here we can use, yes, the unilateral mistake that this mistake was a great because of not normal conditions in the YAPL or in the cryptocurrency prices. So this unilateral mistake is considered enough to consider this contract void. I don't know if I answered your question, Omar.
Okay, fine, totally fine. Thank you. So we can now move to Middlesex University, Team K, and it's the time for the junior appellate rebuttal. I don't know who will be the rebuttal.
If I can just have a moment, Your Ladyship, to refer to
Sure.
my notes.
Just take your time. We can be back in 5 minutes if you want to. If everyone agrees.
Less than 5 minutes also is good.
Okay, perfect. Thank you. Okay.
Yes, Your Ladyship.
You're ready? Please, the stage is yours.
I would like to reiterate and re-emphasize, Your Ladyship, on the principle of the assumption of risk that Ms. Razi has clearly not considered when as was demonstrated by the co-counsel. The assumption of a risk is in the appellant's point of view is that it's actually a substantial part of this dispute. The way that the program was coded to complete legal, legitimate transactions automatically without human approval is, in this day and age even, the appellant side concludes that it can be categorized under what is risky business or commercial behavior. Ms. Razi should take responsibility for the way that she had programmed the program itself to complete the transaction without the need of her consent or approval. Thus, what can be done at the moment is legally and under a point of the law, and as established previously, Your Ladyship, the transaction concluded is indeed a legal and legitimate one, under the way that the program had been coded, and given the various sources of laws cited by myself and my co-counsel, I urge your ladyship to consider our points of view and allow the appeal submitted by the appellate side. Thank you very much.
Thank you. You don't have anything else to add? No? It's okay? You
No,
have
your
more?
ladyship.
Okay. And I will ask you another question, always regarding this leading case that was cited also in your in the case, in the guidelines for facing the case. What do you think could be bring and not could be bring in your case? Because of course there are some aspects that they are not favorable to your client regarding this case. So I would make more or less the same question that I made to your colleague before. What do you think about this case, and what do you think that what do you think are the legal principles that you can take from this case and apply to our case here in the IFC, the Clevity case?
In the instant case, it's obvious that there has been a mistake that had been, or a glitch, if I can rephrase that, a glitch that had taken place in the program. One may argue that there was a unilateral mistake which took place in this case. However, due to the complexity and the nature of the way that the transaction had been designed to take place, we find that legally at the moment it does not fit under the category of a mistake under common law principles in general, and also under the laws, specifically the law number 6 of the DIFC, contract law. So we find that one of the main principles is that under the definition of a mistake, what had undergone here and the outcome of this case does not fall under what is defined as a mistake in the laws applicable. And we also, again, strongly emphasize the principle of the assumption of risk by Ms. Raz Rani. So these are the main principles that I would like to bring to your attention, Your Ladyship.
Perfect. Thank you very much. I will come back for a while to counsel for Lebanese University. Just a quick question. What do you think about the assumption of risk in this kind of transaction? Do you think that it's merely a risk of business, or do you think that you can add something more to this simply merely risk of business? Because at the end of the day, if we have a contract, we need some specific elements. Just a quick reflection, just a quick thought, if you have. Thank you.
Yes. Regarding the assumption of risk, it's correct, but this risk must be a reasonable one. That means, for that, if a contract, let's say, for example, to clarify this, my point of view, if a contract, there was a difference between the obligation between the two parties. One of the parties was obliged through extreme obligations, and the other party wasn't. That this contract is considered voidable. It can be voidable by the court. Applying this concept in our case, it's right. Every person must, especially in this, must take a risk. But this risk must be a reasonable one. Not take a risk that leads to an unbelievable or abnormal prices. For that example, in a normal circumstance, this operation will be balanced. The obligation of the obligation or the interest of the obligation of Mr. Payne and Mr. Razi will be equal. However, in this case, the price was very high. This is abnormal one. Your Honor.
Thank you. Thank you very much. Thank you very much for your answer. If one of the team has something to add, not just regarding ground 2, but also regarding ground 1, so regarding the ground for jurisdiction, please just raise your hands if you want to add something. Otherwise, thank you very much for your time, for your efforts, and I have no more questions to ask. Okay, I think.
Yes, I don't think the appellant side has any further questions, Your Ladyship.
Sorry?
Let me repeat that. I said I don't think the appellant side has any further questions, Your Ladyship. Thank you very much.
Thank you very much to everyone, and best of luck for the rest of the movie.
Thank you very much, Your Honor.
Thank you. Thank you.
Thank you, Your Ladyship.
Thank you. Thank you, and congratulations for your submissions. Thank you.
Thank you.
Thank you. Bye.